First question. First question. What does the term judicial review mean? It is the authority vested in the hands of Supreme Court to examine whether some legislative enactments or executive orders of both the central and the state government is following the Constitution of India or not. The judicial review seeks to put checks on the powers of the executive and legislature with regards to the principle laid down in the Constitution of India. Second one. Article 124 deals with the establishment and constitution of Supreme Court. Third question. Appointment of acting Chief Justice. Article 223. When the office of Chief Justice of a High Court is vacant or any si- when any such Chief Justice by reason of absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purposes. Fourth one. Justice Verma Committee was constituted to recommend amendments to the criminal law so as to provide for quicker trial and enhanced punishment for criminals accused of committing sexual assault against women. Recently, this committee was in news during the encounter of criminals of Hyderabad rape case. Question 5. Chairman of Rajya Sabha or Speaker of Lok Sabha is the final deciding authority on the question of disqualification by anti-defection. Sixth one. The UT of Andaman and Nicobar Islands come under the jurisdiction of High Court of Calcutta under its Extended Jurisdiction Act 1953. Seventh question. The jurisdiction and power of a high court in so far as they are specified in the constitution cannot be curtailed by both by the parliament and the state legislature, but in other respects the jurisdiction and powers of a high court can be changed both by the parliament and the state legislature. Eighth question. Pragati is an information and communication technology based platform for, as the name reveals, proactive governance and timely implementation. The system is a three-tier system comprising of PM, Secretaries of the Government of India, and State Chief Secretaries. The PM will hold monthly interaction with the secretaries and the chief secretaries via this platform. The interaction will take place on the fourth Wednesday of every month. The day will be called Pragati Day. The issue that will be discussed are picked out from the database related to ongoing program of the government, pending projects and public grievances. The Prime Minister recently chaired the 32nd interactions through Pragati on 22nd January 2020. Question number 9. Article 258. Power of the Union to confer powers, etc. on states in certain cases. Article 257. Control of the Union over states in certain cases. Article 261. Public Acts, Records and Judicial Proceedings. Article 260. Jurisdiction of the Union in relation to territories outside India. Question number 10. Any question regarding the age of the judge of AHC is to be decided by the President after consultation with the Chief Justice of India. AHC means any high court. And the decision of the President is final. Question number 11. The Supreme Court of India was inaugurated on January 28, 1950. It succeeded the Federal Court of India established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessors. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. Before 1950, the British Privy Council had a jurisdiction to hear appeals from India. At present, Supreme Court consists of 34 judges, one Chief Justice and 33 other judges. Question number 12. The rarest of rare doctrine has its origin in Bachchan Singh versus State of Punjab 1980. There, the court declared Section 302 of the Indian Penal Code, which prescribes the death penalty for murders, as constitutionally valid, but bounded its limit by holding that the punishment can only be prescribed in the rarest of rare case. Question number 13. Which one of the following statements about electoral government in India? Article 324 of the Constitution provides for an independent election commission in order to ensure free and fair election in the country. The power of superintendence, director and conduct of election to the parliament, the state legislature, the office of the president and the office of the vice president is vested in the commission. There is to be only one general electoral roll for every territorial constituency. For election to the parliament and the state legislature, by doing this, the constitution has abolished the system of communal representation. The separate electorates which led to the partition of the country. Under Article 82, the Parliament by law enacts a delimitation act after every census. After coming into the force commencement of the act, the central government constitutes a delimitation commission. His delimitation commission demarcates the boundary of the parliamentary constituencies as per provision of the delimitation act. The constitution declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. Consequently, the order issued by the delimitation commission become final and cannot be challenged in any court. Question number 14. The Vishaka guidelines were a set of procedural guidelines for the use in the India in cases of sexual harassment. They were promulgated by the in promulgated in 1997 and were superseded in 2019 by Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Question number 15. National Commission for Scheduled Tribes is the constitutional body as it is directly established by Article 338A of the Constitution. The National Commission for SCs and STs came into being consequent upon passing of the 65th Constitutional Amendment Act of 1990. The commission was established under Article 338 of the Constitution with the objective of monitoring all the safeguards provided for the SC and STs under the Constitution or other laws. National Human Rights Commission is a statutory and not a constitutional body. It was established in 1993 under a legislation enacted by the Parliament, namely the Protection of Human Rights Act 1993, National Commission for Women 1992 and the National Commission for Minorities 1993 are statutory bodies in the sense that they are established by the acts of the Parliament. Question number 16. Aadhaar is a 12-digit number issued by Unique Identification Authority of India to the residents of India after completing the verification process laid down by the authority. Aadhaar is not intended to replace any existing uh, identity card, nor does it constitute proof of citizenship. Aadhaar neither confers citizenship nor guarantees rights, benefits, and entitlements. The Unique Identification Authority of India was established in 2009. It is a statutory authority established by the Government of India under the jurisdiction of the Ministry of Electronics and Information Technology. Question number 17. Which one of the following is not a component of realistic theory? Answer: survival can be assured in cooperation with the international organization. Jonathan Haslam characterizes realism as a spectrum of ideas. Its theory revolves around four central propositions. First one: states are the central actors in international politics rather than leaders or international organizations. The international political system is anarchic as there is no supranational authority to enforce rules. Third one: state act in their relation in self-interest with the international system. Fourth one: states desire power to ensure self-preservation. Question number 18. In Keshavananda Bharati case, the Supreme Court ruled that the constitutional amendments were all were also laws under Article 13 of the Constitution of India, which could be declared void for being inconsistent with fundamental rights. Question number 19. Which of the following statements regarding the scheduled tribes and other traditional forest dwellers recognition of Rights Act 2006 are correct? First point: the Act recognizes forest rights for forest dwelling scheduled tribes who have been occupying the forest land before October 25, 1980. The Act seeks to recognize and vest certain forest rights in the forest dwelling scheduled tribe and other traditional forest dwellers. Question number 20. The, the electronic voting machines have been devised and designed by the Technical Experts Committee of the Election Commission in collaboration with two public sector undertakings, namely Bharat Electronic Limited, Bharat and Electronic Corporation of India Limited, Hyderabad. The EVMs are manufactured by the above two undertakings. Question number 21. The right to information means and include the right to information means the right to information accessible under this act which is held by or under the control of any public authority and includes the right to first point inspection of work documents records. Second point: taking notes, extracts or certified copies of documents or records. Third point: taking certified sample of material. Fourth one: obtaining information in the form of diskettes, floppies, tapes, video cassettes, or in any other electronic mode or through printouts where such information is stored in a computer or in any other device. Question number 22. The National Security Council looks into the economic, political, and strategic security concern of India. It was established in 1998 by the then Prime Minister Atal Bihari Vajpayee. The NSC is the apex body of the three-tiered structure of the National Security Management System in India. The three tier are the Strategic Policy Group, the National Security Advisory Board, and a secretariat from the Joint Intelligence Committee. Beside the NSA, the Deputy National Security Advisors and the Minister of Defense, the Ministry of External Affairs, Ministry of Home Affairs, Minister of Finance and Deputy Chairman of Niti Aayog are members of the National Security Council. The National Security Advisor is the Chief Executive or National Security Council and primary advisor to Prime Minister on national and international security and overseas strategic issues. It is NSA to whom intelligence agencies such as Research and Analysis Wing (RAW) and the Intelligence Bureau report rather than directly to Prime Minister. Question number 23. The National Human Rights Commission is a statutory body. It was established in 1993 under a legislation enacted by the Parliament. namely the Protection of Human Rights Act 1993. This act was amended in 2006. It was established in conformity with the Paris Principles adopted for the promotion and protection of human rights in Paris and endorsed endorsed by the General Assembly of the United Nations on 20th December 1993. The Commission is a multi-member body consisting of a chairman and four members. The chairman should be a retired Chief Justice of India and members should be serving or retired judges of the Supreme Court, a serving or retired Chief Justice of the High Court, and two persons having knowledge or practical experience with respect to human rights. The Commission also has four ex officio members: the chairman of the National Commission for Minorities, the National Commission for SCs, and the National Commission for STs, and the National Commission for Women. The chairman and the members hold office for the term of 5 years or until they attain the age of 70 years, whichever is early. Question number 24. Article 348 Clause 1 of the Constitution of India provides that all proceedings in the Supreme Court and in every High Court shall be in English language until Parliament by law otherwise provides. Even question number 25. Even before the complete defeat of the enemy countries, namely Germany, Japan, Italy, in the Second World War, the Allied powers led by USA, former Soviet Union, and UK started planning a organization in place for the League of Nations uh, organization in place of the League of Nations. In order to bring the quarreling countries to talk and negotiate for peace, countries like the USA, the USR, and UK wanted a world forum. The result of their tireless effort was the birth of United Nations organization. The charter indicates at the very beginning four broad objectives of the United Nations. They are to maintain international peace and security through collective measures for suppression of aggression and through peaceful settlement of disputes. Second point, to develop friendly relation among countries based on full respect for the principle of equality and self-determination. Third point, to achieve international cooperation in the economic, social, and cultural and humanitarian fields. Fourth point, to encourage respect for human rights and fundamental freedoms. Thus, all round welfare of people is not explicitly mentioned. The UN has not resolved all the major global disputes. Palestine was admitted as non-member observer status in United Nations, but the dispute with Israel is not yet entirely solved. Question number 26. A person appointed as the judge of High Court before entering upon his office has to make and subscribe an oath or affirmation before the governor of the state or some person appointed by him for this purpose. Question number 27. A political revolution is a forcible removal of the power structure by a group of people and the implementation of a new power structure. Basically, a revolution in the group of people arising up to overthrow the government with the intent of setting up an improved system. There, there are some cases where the government is not completely overthrown but is profoundly changed or managed or modified. Usually, a resolution happens relatively quickly, although in some cases it can drag out over the course of decades. In addition to changing power structure, revolutions also usually affect changes in economic and society as a whole. Question number 28. The e-courts project was conceptualized on the basis of the National Policy and Action Plan for Implementation of Information and Communication Technology in Indian Judiciary 2005, submitted by E-Committee, Supreme Court of India, with a vision to transform the Indian judiciary by by ICT, that is Implementation of Information and Communication Technology. enablement of courts. The e-court mission mode project is a pan-India project monitored and funded by the Department of Justice, Ministry of Law and Justice for the district court across the country. Question number 29. Political parties are voluntary association or organized group of individuals who share the same political view and who try to gain political power through constitutional means and who desire to work for promoting the national interest. Basically, political parties fill political offices and exercise political power. Parties do so by performing a series of functions. Parties contest election. Parties put forward different policies and programs and the voters choose from them. Parties play a decisive role in making law for a country. Formally, laws are debated and passed in the legislature. Parties form parties form and run governments. Those parties that lose in the election play a role in opposition to the parties in power by voicing different views and criticizing government for its failure and wrong policies. Parties shape public opinions. They raise and highlight issues. Parties provide people access to government and machinery and welfare schemes implemented by government. Question number 30. Cons- uh, Euthanasia is a practice of intentionally ending life to relieve pain and suffering. Different countries have different euthanasia laws. The Supreme Court ruled that individuals had a right to die with dignity, allowing passive euthanasia with guidelines. The need to change euthanasia law was triggered by the famous Aruna Shanberg case. The top court in 2011 had recognized passive euthanasia in Aruna Shanberg case, by which it had permitted withdrawal of life-sustaining treatment from patients not in a position to make an informed decision. Since March 2018, passive euthanasia is legal in India under strict guidelines. Patients must consent through a living will and must be either terminally ill or in a vegetative state. As of March 2018, active human euthanasia is legal in the Netherlands, Belgium, Cambodia, Luxembourg and Canada. Question number 31. The National Commission for Women is a statutory body of the Government of India generally concerned with the advising the government on any policy matters affecting women. The National Commission for Women was set up in 1992 under the National Commission Act 1990. The first commission was constituted on 31st January 1992 as Jayanti Patnaik as the chairman. Question number 32. The Chief Election Commissioner and the two other election commissioners hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. They can resign at any time or can also be removed before the expiry of their term. Article 324 of the Constitution has made the provision to safeguard and ensure the independent and impartial functioning of the Election Commission. Question number 33. In the famous Gopalan case 11, 1950, the Supreme Court has taken a narrow interpretation of the Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21. Question number 34. Custodial death of a father and son in Shakuntalam town in Tamil Nadu, Thoothukudi district has brought the question of police brutality to the fore due to which SC laid guidelines for arrest by police personnel. The guidelines for arrest of personnel by the police were given by the Supreme Court in which of the following cases? Answer. D.K. Basu versus State of West Bengal. Question number 35. To be eligible for appointment as Attorney General of India, a person must possess the qualifications prescribed for the judge of the Supreme Court. However, he holds office during the pleasure of the President. Question number 36. Consider the following statement. Select the answer from the codes given below. Assertion A. In India, every state has a high court in its territory. Reason. The Constitution of India provides for the high court in each state. Assertion is wrong and reason is correct. Question number 37. Match list 1 with list 2. Select the correct answer by using given codes. Andaman and Nicobar Islands. Fourth one. Under Calcutta High Court. Dadra and Nagar Haveli. Under Bombay High Court. Lakshadweep under Kerala High Court. Puducherry under Madras High Court. Question number 38. Below the district and session court and the court of the subordinate judge on the civil side and the court of the chief judicial magistrate on the criminal side, subordinate judge exercise unlimited pecuniary jurisdiction over civil suits. Chief judicial magistrate decides criminal case which are punishable with imprisonment for up to 7 years. Question number 39. The writ of prohibition is issued by the High Court to the lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. The writ of certiorari is issued by High Court to the lower court or tribunal either to transfer the case pending with the latter to itself or to squash the order of the latter in the case. Question number 40. Article 124 to 147 in Part 5 of the Constitution deals with the organization, independence, jurisdiction, power and procedures on the of the Supreme Court. Unlike American Supreme Court, the Supreme Court of India has advisory jurisdiction. The Constitution under Article 143 authorizes the President to seek the opinion of the Supreme Court. Question number 41. The Election Commission of India is permanent and independent body established by the Constitution of India directly to ensure free and fair election in the country. Article 324. Superintendent's direction and control of election to be vested in the Election Commission. The Constitution has not prescribed the qualification of the members of the Election Commission. The Constitution has not specified the terms of the members of the Election Commission. Question number 42. Judges of Supreme Court used to be appointed by the President of India, who acted on the advice of the Union Cabinet. A judge of Supreme Court can be removed by the procedure prescribed in Article 124, Clause 4 of the Constitution of India on grounds of proved misconduct or incapacity or judge resigning from his office addressed to the President of India. Question number 43. Law Commission of India is neither a constitutional body nor a statutory body. It is an executive body established by an order of the Government of India. Its major function is to work for legal reforms. The Commission is established for a fixed tenure and works as an advisory body to the Ministry of Law and Justice. Its membership primarily comprises legal experts. The Government of India established the first Law Commission of Independent India in 1955 with the then Attorney General of India, Mr. M.C. Sethalwad, as its chairman. Since then, 21 more law commissions have been appointed, each with a three-year term. The recommendations of the commissions are not binding on the government. They may be accepted or rejected. Actions on the said recommendations depends on the minister's department which are concerned with the subject matter of the recommendations. Question number 44. Writs of habeas corpus means to have the body off. It is an order issued by the court to a person who has detained another person to produce the body of the letter before it. The court then examines the cause and legality of detention. It would set the detained person free. If the detention is found to be illegal, the writ is not issued where the detention is lawful. The proceeding is for contempt of the legislature or a court. Detention is by a competent court. Detention is outside the jurisdiction of the court. Question number 45. Article 343. Official language of the Union and the official language of the Union shall be in Devanagari script. The form of numerals to be used for the official purpose of the Union shall be international forms of Indian numeral, notwithstanding anything in clause 1 for a period of 15 years from the commencement of this constitution. The English language shall continue to be used for all the official purposes of the Union for which it was being used immediately before such commencement, provided that the President may, during the said period, by order authorize the use of Hindi language in addition to the English language and of the Devanagari form of numeral in addition to the international form of Indian numerals for any of official purpose of the Union, notwithstanding anything in this article. Question number 46. A member of a house belonging to any political party becomes disqualified for being a member of the house. First point, if he voluntarily gives up his membership of such political party or if he votes or abstains from voting in such house contrary to any direction issued by his political party without abstaining prior permission of such party and such act has not been condemned by the party within 15 days. The disqualification on the grounds of defection does not apply in the case if the member goes out of his party as a result of merger of the party with the party. A merger takes place when two-thirds of the members of the party have agreed to such merger. The provision of the 10th schedule pertaining to exemption from disqualification in case of split by one-third members of legislature party has been deleted by the 91st Amendment Act of 2003. Question number 47. Lok Adalat. Lok Adalat means People's Court is one of the alternative dispute resolution mechanism where the case of disputes which are pending in the court or which are at pre-litigation stage are settled in an amicable manner. It is a statutory body under the Legal Services Authorities Act 1987. It can hear both civil and criminal cases. This system is based on Gandhian principles. Lok Adalats serve very crucial functions in India due to many factors like pending cases, illiteracy, poverty, high vacancy in courts, etc. The decisions made by the Lok Adalat is deemed to be a decree of a civil court and is final and binding on all parties, and no appeal against such an award lies before any court of law. If the parties are not satisfied with the award of the Lok Adalat though there is no provisions for an appeal against such an award, but they are free to initiate litigations by approaching the court of appropriate jurisdiction by filing a case by following the required procedure in exercise of their right to litigate. Question number 48. Attorney General of India is part of Union Executive, can address either House of Parliament but cannot vote, must have the qualification of Judge of Supreme Court to hold the office. Question number 49. The Supreme Court has the exclusively jurisdiction in relation to federal cases. Question number 50. The members Which of the following are the members of the Delimitation Commission? The members are retired judge of the Supreme Court, Chief Election Commissioner, respective state election commissioner. Question number 51. Article 280 provides for the Finance Commission as a quasi-judicial body. It is required to make recommendations to the President on the following matters. First one, distribution of net procedure of tax to be shared between the center and the state, and the allocation between the state the respective share of such procedures. Second, the principles which should govern the grants in aid to the state by the center out of the consolidated fund of India. Third point, measures needed to augment the consolidated fund of state to supplement the resource of panchayat and municipalities in the state on basis of the recommendations made by the State Finance Commission. Question number 52. State Election Commission is a constitutional body formed through 73rd and 74th Constitutional Amendment Act for conducting the election of panchayat and municipalities. They are appointed by the governor of the concerned state. Question number 53. The original jurisdiction of Supreme Court of India extends to dispute between different units of Indian Federation. This means any dispute between the center and one or more states, or second point, center and any state or states on one side and one or more sides on the other. Third point, between two or more states. In these federal disputes, the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such disputes, and original means the power to hear such disputes is in the first instance, not by way of appeal. Question number 54. The Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the state High Court below it. This single system of court enforces both the central laws as well as the state laws. In US, on the other hand, there is a double system of courts whereby the federal laws are enforced by the federal judiciary and the state laws by the state judiciary. The organizational structure, jurisdiction, and nomenclature of the subordinate judiciary is laid down by the state. Hence, they differ slightly from state to state. Question number 55. The President has assigned the following duties to the Attorney General. First one, to appear on behalf of Government of India in all the cases in Supreme Court in which Government of India is concerned. Second, to represent the Government of India in any reform made by the President to the Supreme Court under Article 143. Third one, to appeal when required by the Government of India in any High Court in any case in which the Government of India is concerned. Question number 56. Judicial review is based on procedure established by law. Question number 57. Writ of prohibition is not available against a public officer not vested with judicial or quasi-judicial powers. Question number 58. Jurisdiction and power. Which of the following are the main jurisdiction of the High Court of the state? At present, the High Court enjoys the following: original jurisdiction, appellant jurisdiction, supervisory jurisdiction, control over subordinate courts, a court of record, power of judicial review. Question number 59. The district judge is the highest judicial authority in India. In district. The district judge is the highest judicial authority in the district. Possesses original and appellant jurisdiction in both civil as well as criminal matters. In other words, the district judge is also that session judge. When he deals with the civil cases, he is known as the district judge. When he hears the criminal cases, he is called the session judge. The district judge exercises both judicial and administrative power. He also has supervisory power over all the subordinate courts in the district. Question number 60. The Chief Justice of Supreme Court has the right to establish the bench of the Supreme Court elsewhere in the country with prior approval of the President. Question number 61. The writ jurisdiction of the High Court is wider than that of Supreme Court because the Supreme Court can issue writs only for the enforcement of fundamental rights and not for the other purpose. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights but also for other purpose. Question number 62. Under Article 143 of the Indian Constitution confers upon the Supreme Court advisory jurisdiction. The President may seek the opinion of the Supreme Court on any question of law or fact of public importance on which he thinks it expedient to obtain such an opinion on such reference from the President. The Supreme Court, after giving it such hearing as it deems fit, may report to the President its opinion thereon. The opinion is only advisory, which the President is free to follow or not to follow. Question number 63. Constitutional 103rd Amendment Act 2019 was empowered the state to provide up to 10% reservation in education of public employment for economically weaker sections of citizens other than scheduled caste, scheduled tribe, and non-creamy layer of other backward classes. Question number 64. Consider the following statement about Attorney General of India. He is appointed by the President of India. He has the right to take part in the proceedings of the Parliament. He has the right to audience in all courts in India. All the statements are correct. Consider the following statements and choose the correct options from the alternatives given below. The minimum entry age and duration of his tenure is not fixed by the Constitution. However, the maximum age up to which judges of Supreme Court can hold the office is up to 65 years of age. Question number 66. Advocate General of State is appointed by the Governor of the State and holds the office during the pleasure of the Governor. Question number 67. Comptroller and Auditor General of India is appointed by the President of India by a warrant under his hand and seal, but it is not a multi-member body. CAG holds office for the period of 6 years or up to age of 65, whichever is earlier. The Constitution, Article 149, authorizes the Parliament to prescribe the duties and power of the CAG in relation to the accounts of the Union and of the state and of any other authority or body. Accordingly, the Parliament enacted the CAG Duties, Power and Conditions of Service Act 1971. This act was amended in 1976 to separate accounts from audit in the central government. CAG can be removed by the President only in accordance with the procedure mentioned in the Constitution, that is the manner same as removal of the Supreme Court judge. Question number 68. The Supreme Court decides the disputes between different units of the Indian Federation, that is the dispute between the center and one or more states, the center and any state or state on one side and one or more side on the other, between two or more states. The Supreme Court has exclusive original jurisdiction in the above federal disputes. No other court can decide such disputes, and original means the power can hear such dispute in the first instance, not by the way of appeal. Question number 69. Which one among the following is the distinguishing factor between the pressure group and the political party? Answer: pressure group do not seek active political power. Political parties do. Question number 30. The 9-judge bench in the Bommai case adjudicated on a range of issues around the constitutional limitations of the use of Article 356. On the question of invoking Article 356 in the case of failure of constitutional machinery in states, suitable amendments are required to incorporate the guidelines set forth in the landmark judgment of the Supreme Court in S.R. Bommai versus Union of India 1994. This would remove possible misgivings in this regard of the part of state and help in smoothing center-state relation. Since the Constitution came into force, President's rule under Article 356 has been imposed on state on over 100 occasions without any concrete reason. This instance, however, declined considerably after S.R. Bommai ruling. Question number 71. Which of the following statements with regard to Finance Commission in state is not correct? Answer: Chief Minister of the state decides the composition of the Finance Commission and nominates the chairman. This statement is wrong. The correct statements are: the 74th Amendment of the Constitution of India provides for the establishment of Finance Commission by a state to review the financial position of the municipalities. Under Article 243I of the Constitution of India, the Governor of the state is required to constitute a Finance Commission every 5 years. The Finance Commission is expected to recommend the division of resource between the state and municipalities within the state. The Finance Commission is authorized by law recommendations with regard to grants in aids to panchayats from the consolidated fund of a state. Question number 72. The total number of the members of the Legislative Council consists of the member of local bodies in the state, graduates of 3 years and residing within the state. Nearly 1/12 of its members shall be elected by the person who have been for at least 3 years engaged in teaching in such educational institution within the state, not lower in standard than that of a secondary school. Question number 73. A registered voter in India can contest in election to Lok Sabha from any constituency in India except autonomous district of Assam, Lakshadweep and Sikkim. According to Section 8 of Representation of People Act 1951, a person convicted of any offence and sentenced to imprisonment for not less than 2 years, other than any offence referred to in subsection A or subsection B, shall be disqualified from the date of such conviction and shall not be disqualified for a further period of 6 years since his case. Question number 74. What does the writ of quo warranto mean? It is issued when the court finds that the office order is illegally holding that position. Question number 75. The Parliament can establish a joint state public service commission for 2 or more states on the request of the state legislature concerned. The chairman and members of the joint state public service commission is appointed by the president. Question number 76. Central Information Commission was established in 2005. All the members are appointed by the Honorable President of India. Question number 77. Consider the following statement. The member of the State Public Service Commission are appointed by the President and they can be removed only by the concerned state governor. The member of the State Public Service Commission is appointed by the governor of the concerned state. They can only be removed by the president. This statement is correct. Question number 78. This is the following statement on PIL. Public interest litigation is meant to bring justice to the doorstep of the weak, the unorganized and exploited section of society. Second point, it is for those who have no access to the courts because of the prohibitive cost of litigation. It is brought before the court not for the purpose of enforcing the right of one individual against others. Question number 79. Which of the following initiatives of Niti Aayog? Initiative Niti Aayog are first one 15-year roadmap, second 7-year vision strategy and action plan, Amrit, Digital India, Atal Innovation Mission, medical education reform, agricultural reform, models like leasing law, reform of agriculture produce marketing committee act, agricultural marketing and farmer friendly reforms. Question number 80. Proportional representation. It is in proportional representation, a candidate requires 50% plus 1 vote to get elected. In the bi-party system, one automatically secures it. Proportional representation is a concept in voting system used to elect an assembly or council. PR means that the number of seats won by a party or a group of candidates is proportionate to the number of votes received. Question number 81. Electoral reform are changes in electoral system to improve how public desires are expressed in election result. Installation of electronic voting machines is not the part of such reform. Question number 82. A person who has been Chief Justice of Supreme Court or a judge of Supreme Court will be the chairperson of National Human Rights Commission. Question number 83. Paris Principles, which are a set of international standards, are related to. The internationally agreed Paris Principle define the role, composition, status and function of national human rights institutions. National human rights institutions must comply with the principle which identify their human rights objectives and provide for their independence, broad human rights mandate, adequate funding and an inclusive and transparent selection and appointment process. The principles are broadly accepted as the test of the institution legitimacy credibility. Question number 84. Which of the following are true regarding power and function of the Central and the State Information Commission? Answer: the Central Commission submits an annual report to the Union Government. Question number 85. Which of the following are true regarding the composition of the Central Vigilance Commission? Answer: the Central Commission submits an annual report to the Union Government. Central Vigilance Commission. It is aimed at preventing corruption and was established by executive resolution of the Union Government in 1964. Shantanam Committee on Prevention of Corruption recommended its formation. It was only recently in 2003 that a law was passed giving statutory status to CVC. This authorized the CVC as the designated agency to receive written complaints for disclosure of any allegation of corruption or misuse of office and recommended appropriate action. Question number 86. Which of the following statements are correct with respect to the Whistleblowers Protection Act 2011? The Act does not allow anonymous complaints, but there are no clear provisions on what grounds the Vigilance Commission may reveal the identity of the complaint to the head of an organization. Some experts contend that allowing anonymous reporting provides protection to whistleblowers, while others have expressed concern about difficulty of investigation and possibility of frivolous complaint. Countries such as the US, UK, Canada, Australia have some provisions to investigate anonymous complaints. The Act does not provide for the Witness Protection Program to provide witness during investigation and trial. The Law Commission has recommended guidelines for witness identity protection. Countries such as US, Canada, Australia, Germany, Italy, South Africa have witness protection programs. The Act does not define what constitutes victimization. The definition given in the statement is the definition suggested by the Law Commission. Question number 87. The mobile app CVigil is helpful in reporting violation of model code of conduct in election bound states. Question number 88. The state election commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of the High Court. The state legislature has the power to legislate on all matters relating to the elections of panchayat. Question number 89. Which of the following statements is about Central Bureau of Investigation? It is not a constitutional institution. It was set up by resolution of the Ministry of Home Affairs in 1963. It helps in Central Vigilance Commission. Its mission is to protect the constitution and the law of the country. Question number 90. Meteorological branch does not belong to Central Bureau of Investigation but is related to Meteorological Department. Question number 91. Consider the following statement. CAG is not eligible for further office like election commissioner. The salary, allowance and pension of CAG are charged upon the Consolidated Fund of India. Both the statements are correct. Question number 92. Niti Aayog replaced the Planning Commission of India. Niti Aayog, head office Delhi. Prime Minister is the chairman. Parent agency is Government of India. Question number 93. The National Commission for SCs is also required to discharge similar functions with regard to the other backward classes and Anglo-Indian community as it does with respect to the SCs. In other words, the Commission has to investigate all matters relating to the constitutional and other legal safeguards for the OBCs and the Anglo-Indian community and report to the President upon their working. Question number 94. With reference to the Finance Commission of India, which of the following statements are correct? Finance Commission is not vested with such powers like it allows the withdrawal of money out of public account of India. It ensures transparency in financial administration. These all statements are wrong. Question number 95. Salary, pension, allowance of the chairman and members of the Union Public Service Commission were by the Consolidated Fund of India. Question number 96. Both the National Commission for SC and National Commission for ST, while investigating any matter or inquiry into any complaint, has all the powers of the Civil Code. Trying a suit, Union Public Service Commission is not vested with such powers. Question number 97. Which article empowered the President to constitute a GST Council by an order? Answer 279A. The 101st Amendment Act of 2016 paved the way for the introduction of the new tax regime, goods and service tax, in the country. The smooth and efficient administration of these taxes requires the cooperation and coordination between the state and the center. In order to facilitate this consultation process, the amendment provided for the establishment of goods and service tax council and the GST council. The amendment inserted in new article 279A in the constitution. This article empowered the president to constitute GST council by an order. Accordingly, the president issued the order in 2016 and constituted the council. Question number 98. Consider the following statement about the Special Officer for Linguistic Minorities. It was created in pursuance of the provision of Article 350B of the Constitution. The Commissioner has its headquarters at Allahabad. He has 3 regional offices at Belgaum, Chennai and Kolkata. Each is headed by the Assistant Commissioner. He maintains the relation with the state government and the union territory through the nodal officers appointed by them. Question number 99. Which Amendment Act bifurcated the combined National Commission for SC and ST? Answer 89th Constitutional Amendment Act. Question number 100. With reference to Union Public Service Commission, which of the following statements are not correct? Neither one nor two. The Union Public Service Commission is the central recruiting agency in India. This statement is correct. It is an independent constitutional body in the sense that it has been directly created by the Constitution. The UPSC consists of chairman and other members appointed by the President of India. All the statements are correct. Usually the commissioner consists of 9 to 11 members including the chairman. The chairman and the members of the commission holds office for the term of 6 years or until attain the age of 65 years, whichever is early. All the statements are correct.